Good evening. My name is David Kershaw. I'm the law clerk for the Richland County Probate Court. Unfortunately, Judge McCullough could not be here this evening, so she sent me in her stead, and she's very sorry, but she just could not make it. I just want to give a quick general overview of what the probate court is, what we're doing here in Richland County. There's actually 46 probate courts because there's 46 counties, each county having their own judge. Our elected judge here is Amy W. McCullough. Our probate court is relatively large in staff. Judge McCullough is the probate judge. She has a full-time associate judge, Judge Jacqueline Belton, and we have 2 part-time associate judges, Judge Kane Darby and Judge Nancy Moody. The probate court's duties. We administer the estates of decedents, we issue marriage licenses, appoint guardians for incapacitated adults, appoint conservators for minors and incapacitated adults. We order involuntary commitment of the mentally ill or the chemically dependent. We hear and decide estate and trust litigation, and we oversee adult and juvenile mental health courts. Sometimes talking about the probate court, some people say, oh, it's the place you don't want to go. Kind of agree, but I consider us to be the rainy day court. When there's a rainy day, we're there in the storm with you. We're there giving you the umbrella. When you decide to get married and you want to share that umbrella with somebody, we're there for you. When you want to extend an umbrella to a family member, a loved one, to make sure that they're getting their health care needs met, we're there for you through that storm. So that's kind of how I like to think of the probate court. Our estates division. We have regular estates, which consists of intestate and testate. Intestate and testate are just legal terms. That means, intestacy means there is no will. That means that you have your heirs. Testate means that the person passed away with the will. These may be administered formally or informally, and the typical administration period for an estate is about a year. Then we have small estates. A small estate is where the estate assets are valued at less than $25,000 and there's no real property. So there may just be a car in a bank account that don't add up to be $25,000 or more. You can open a small estate for that and not have to go through the full estate process. Taxable estates. The gross estate exclusion for federal tax returns is $5,450,000. So that's hopefully where I'll be one day. And I wish the same for all of you. But if you are in that tax bracket, please seek out probate attorney. You will need some help with that. I'm not great with taxes myself. Just had to file mine last night. Our records division. The probate court maintains records related to all the estates, guardianships, conservatorships, marriage licenses, and commitments for Richland County. Most of the estate records and the marriage licenses are public access. You can go view them, you can see what's going on within the estate, you can find all the marriage licenses that were issued by Richland County. However, most of the guardianships, conservatorships, and commitment records are not available to the general public. Because we have in guardianships, conservatorships, and commitment records, very sensitive health information, doctor's affidavits, things that go towards the mental health issues, any kind of background checks that may be done, those things are more so only issued by court order. So that's only if you need it, you've basically asked in writing, the court release it for a certain reason, and the judge has to approve it. Members of the public are welcome to visit the probate court and view records. Estate records are available from the year 1900 to the present day. Marriage license records are available from the year 1911 to the present day. Records from 1900 to 1972 can be viewed on a microfilm roll machine. Records from 1973 to 1994 can be viewed on a microfiche jacket. And all records filed after January 1st, 1995 have been scanned, imaged, and are viewable on public computers and through the internet. This last one is kind of big for our county. We're very proud of it. We spend a lot of time making sure that what needs to be available to the public is available to the public. We have, I think now, 12 estate clerks, and every day when they're not helping someone, they're making sure that all the records are updated, are available, and we try to get everything that comes into our office turned around, scanned, imaged, indexed, ready for you to view it if you need it within 24 hours. Members of the public may make copies of any records for 50 cents per page. If you come upstairs to room 207, which is literally around the corner from here, our main lobby, we have computers where you can print off anything you want, but there's a 50 cent per page fee that we must charge. Interested parties to an estate can view and print documents through the internet. We have an SMS system online. If you go to rcgov.us/probate, in the upper right-hand band, you'll see online services, and you can view for a fee. It's a daily fee, or you can do a weekly subscription, and you can view anything you want, print anything you want. Depending upon your interest in the estate and how many documents you need, we kind of tend for people to do that because it'll be cheaper than coming up here and printing 50 cents a page and then getting home and realizing, oh, I missed page 3. So that's a very good thing for us to have. Our Guardianship and Conservatorship Division. A guardianship is a court-appointed individual who manages healthcare needs of an incapacitated adult. Adult being the key word. If you're thinking guardianship as far as a minor, that's family court matter. We are involved with the incapacitated adults, where you want to take care of mom, dad, someone who's unable to provide for their daily needs anymore. A conservatorship is a court-appointed individual who manages the financial affairs of an incapacitated adult or a minor receiving assets in excess of $10,000. So this is where the guardianship and conservatorship bridge, but when it comes to minors, if a minor receives more than $10,000 from an insurance settlement, from an estate, those type of things, by law, a conservatorship has to be established for them, and those funds have to be held in a conservatorship account until they turn age 18. Our marriage license division, where bride and groom must appear together to apply, or I should say where two individuals, excuse me, this needs to be slightly updated, must appear to apply. They must both be there. So you can't say, oh, they're coming later, they'll sign it later. No, we need both of you there so that we can say, you want to marry this person? You want to marry this person? Great. Not, well, I'm thinking about marrying this person. I'll come back later, and then maybe they'll change their mind. And we've had the slightly awkward occasion where someone decided to take a field trip with somebody and not tell them where they're going and get down on one knee, and they didn't leave with a marriage license, unfortunately. But it would have been beautiful if she would have said yes. But she was a little bit thrown off by, you just went on a field trip. But we need both of you there to say, yes, I want to marry the person standing beside me. You must bring an official photo identification. That can be your driver's license, a military ID, a South Carolina identification card, or your passport. We also need you to have either your Social Security card or some documentation. Most people use like a W-2 that has your full social. So if you have something that's star, 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 and the last 4, that won't work. We need to see the full social next to your name. Also, there's a $43.50 fee that you can pay in cash, but if you use a debit or a credit card, it'll be $45.22. And there's also a 24-hour waiting period. So if you come in today and you get your marriage license, all the information, you pay the fee, you can't get married today. You have to wait 24 hours and you can come back. When you come back, we don't need both parties to be there to pick up the marriage license because you pretty much already said, I want to marry this person, that's fine, I've signed for it, you have all my information. Either one of you can come back and pick it up, either bring the receipt or bring a copy of your photo ID. Our commitment division. The probate court handles involuntary commitments for mental illness and chemical dependency. Petitions for non-emergency treatment are processed at Columbia Area Mental Health Center. Petitions for emergency treatment are processed during regular office hours at Columbia Area Mental Health Center or after hours at Palmetto Richland Emergency Room. Emergency commitment is necessary when an individual poses immediate threat to self or others. So when there's a mental illness issue involved typically, and that person has threatened to harm themselves, threatened to harm someone else, and they won't voluntarily go to a hospital and say, I need help, that's when the probate court has to step in and issue an order to have that person committed to get the help that they need. Our mental health court, we have an adult court diversion program, which has been in place since 2003. We also have a newer juvenile court diversion program that has been in place since 2014. This is available to individuals diagnosed with a mental illness and charged with a misdemeanor or non-violent felony offense. Intensive care management and supervision provided to each participant based on individualized treatment plans. Successful completion of the mental health court results in a dismissal of the charges in summary courts. So basically the point of the mental health court is to somewhat steer away from incarceration, those who may have acted because they have a mental illness. We want to focus on treatment in Richland County for those who have a mental illness, as opposed to a punishment route. And that's where we go. And we also delineate from adult to juvenile, because there are different issues that need to be more specifically looked at when you're dealing with a minor versus an adult. So there are 4 documents that everyone needs to have. You should have a will, a durable power of attorney, a health care power of attorney, and a living will. Your will, it has to be in writing. In the state of South Carolina, your will has to be in writing. What someone says on their deathbed doesn't count here. South Carolina law requires that it be in writing to be a valid will. You have to clearly state your desires for the transfer of your property. You should name a personal representative and a successor personal representative. The personal representative is what some people call the executor, the person who's administering the estate. So not only put one person in your will, but it's better to have 2 people. In case the first person, for whatever reason, is unable to do it, they're unavailable to do it, they may be out of the country, out of the state, and it's just better to have that second person as a backup so that you know a person that you trust is still going to administer your estate. Give the personal representative authority to sell your real and personal property. This is very important. One of the great things about a will is that you can really see how you want things to go, but when you come into the administration portion, some things may have changed. If the personal representative has the authority to sell, that gives him the authority to make sure that your debts are taken care of, making sure that some of the assets can be sold if need be to ensure that your wishes are fully carried out. Another requirement, it needs to be signed by the testator and dated. And the last, it has to be witnessed by 2 people, this is very important, who are not beneficiaries, who are not married to the beneficiaries, and who are not parents of a beneficiary. So let's say you just met this boy, David Kershaw, and you decide you're gonna give him $1 million in your will. David Kershaw cannot sign the will as one of your 2 witnesses. You need someone who's totally disconnected. So my mother can't do it, my wife couldn't do it. Needs to be disconnected from your son, your daughter, your children. Whomever you're naming in your will, don't have them be your witness. What not to do. Do not leave nominal bequests. It will only hurt the feelings of the ones that you love. A nominal bequest is, I left everything to David, but I have 2 children, Amy and Joe, and so I'm going to put in my will that Amy gets $1, Joe gets $1, and David gets everything else. That is something that, for some reason in the South, was at one time considered standard practice, where you just want to name them and give them $5, $1, and you know you're leaving everything to Stacy. Well, don't do that, because not only does it cause ill will, but sometimes it can be an issue of, well, that was a typo. He meant to put $1 million, but he forgot to write the word million, it's just $1. So yeah, you want to be careful with that. Do not leave assets directly to minors. Assets over $10,000 require a conservatorship. So if you have a 6-year-old nephew like I do, and you love him to death like I do, there are other ways to handle it, which I will talk about in a minute. But if I leave my mansion that I don't really own right now to him, it would have to go through the court, be put into a conservatorship, and I would have to have my sister, his mother or father, whomever, be the person over it. It adds more processes outside of the estate issues. Now you're bridging estate issues, conservatorship issues. It gets a little bit messier depending upon how big the assets are and how much he or she's going to inherit. It's just better to deal with it a different way, which we'll talk about in just a second. But most importantly, make sure you update your will after a life-changing event: marriage, birth of a child, a divorce or separation. These issues can become more and more complicated if, I'm married today, I do a will, I divorce next week, it just didn't work out, bad weekend, it rained, who knows. But in the will, I left everything to her. Now, unfortunately, something happens to me, and she's there with a will that says she gets everything. Issues, issues, issues. These life-changing events that change your family dynamic need to be a triggering factor in your mind to update this will. And keep it in a very safe place. You don't want to have it somewhere that's just sitting by the nightstand and something happens, unfortunately, and it gets ripped, torn, shredded, somebody reads it and, oh, I don't really like what it said, and it disappears. So you have a question now?
Who should get copies of your will?
Ma'am? I'm sorry.
Who should get copies of your will?
That's more of a personal preference. When it comes to copies of your will, well, the original should always stay with you because you know where it is. You can safeguard it unless you're giving it to someone that's very trusted to put it away in a safe, preferably something that's fireproof, a lockbox. Those type of things are always better. But when it comes to just having copies of your will everywhere, I would advise against having too many copies of your will everywhere because then what happens if you redo the will? Now you have 5 people with this copy, 5 people with that copy, 5 people with this copy, 5 people with that copy, and then sometimes it's a very personal decision. I think to answer that question, it's going to depend on your trust level, who you think should have it. Someone you really, really trust to have a copy of your will. The original, I suggest, stays with you. Put in a very safe place. The second document that everyone should have is your durable power of attorney. It names a person to manage your assets if you should become incapacitated. It must be recorded in the Register of Deeds office in Richland County, which is downstairs for us on the first floor, right to the left of the security area. It does not have to be a family member. It can be someone who's a non-family member. That's a misconception that some people have, that your POA must be your mother, father, child, aunt. It can be a friend, a very good friend. But it needs to be someone that you trust. That's very important. Someone that you would trust to make these decisions for you. The third document is a healthcare power of attorney. It names a person to make your healthcare decisions for you, which is different than your power of attorney who's making more of your financial business, those type of decisions. It too does not have to be a family member. It does need to be someone you trust, and South Carolina has an approved form which is provided. You were passed out a packet of forms. I think the second form actually is the South Carolina approved healthcare power of attorney. The living will. A living will is a declaration of a desire for a natural death. It states your desire for measures to be taken or withheld should you be in a terminal or vegetative state, You have the power to revoke it and enforce it. It must be witnessed and notarized, and South Carolina has an approved form. I believe that's the first form actually in the materials that I've handed you. This is very important. Every time you go to the hospital, you should take a copy of your healthcare power of attorney and your living will. Because if you have these documents and they're under your mattress, no one knows where they are, you're going to the hospital and something should happen, if you have them with you, we'll know. If you don't, then we can't say what your last wishes were in your living will. Ways to avoid probate. Sometimes coming through the probate system, there are ways that you don't have to do that with certain assets. You can create a trust. If you're concerned about your taxes, privacy, or probates being in multiple states, you can put assets in a trust and have a beneficiary for those trusts, and those trust assets, unless there's trust litigation, hopefully not, won't be a part of your estate. For real property, you can title it as joint tenants with right of survivorship. With right of survivorship is the important language, because that means that if David and Amy have a house, we bought a house, we decided to put it in both our names as joint tenants with rights of survivorship. If something should happen to me and I pass away, Amy automatically inherits it. It does not go through the probate system. Automobiles, boats, and vehicles. So if you and someone else own an automobile, a boat, a vehicle of some kind, and you title it as me or them, if something should happen to either person, automatically the car, the boat, what have you, will become the property of the other person who survived. Life insurance policy, please name a beneficiary. This cannot just be a practical matter, it can be a family dynamic issue. Naming a beneficiary means that as soon as something happens to the owner of the policy, the person who's named as as a beneficiary automatically receives those funds. And a joint bank account works exactly like joint tenants with rights of survivorship. The surviving party automatically gets all the funds within the account. Well, I want to thank you all for being out here and listening to me talk for a little while. And on behalf of Judge McCullough and Associate Judge Jacqueline Belson, if you have any questions or any concerns, please see us in room 207.